Hi there, and welcome to Help Solve the Case. Today we are talking about the Pamela Smart case. She has been incarcerated since 1991 with a life without parole sentence. She was accused and convicted of being an accomplice to the death of her husband, first-degree murder, conspiracy to commit murder, and witness tampering in the 1990 death of her husband, Gregg Smart. Prosecutors said during the trial that she convinced her 19-year-old student, William Flynn, to carry out the shooting. She currently has a habeas petition in that case, and just yesterday, there was a hearing on it. I thought, like I always like doing, we would go over that petition. This is the state of New Hampshire in the Supreme Court of the state of New York, which is really kind of confusing. I really don't understand that. My family is actually from Westchester, New York. This was from New Hampshire. I read that somehow through the Interstate Compact, they can house prisoners for each other. Really kind of crazy. Never seen that before, so I'm not exactly sure what is going on there. And it talks about here the jurisdiction. We will get to that, but I am not really sure what is going on here. We got a lot of pages, a lot to cover, but it should be interesting. This petition was filed January 5th, 2026, and they just now heard the oral argument. It says, comes now petitioner Pamela Smart through her attorneys, Matthew Zernhelt. I don't know what the ProHack Vice or Vice, I mean, it's pending. Maybe he's getting ready for the bar or whatever. I'm not sure. And Jason Ott, we got that same thing. I don't know what that is. It's pending. Maybe they're admitted to the bar in a different state because this is going back and forth between New York and New Hampshire. There's something going on there, not sure. And Daniel DeLugoff and submits this petition for habeas corpus pursuant to New Hampshire revised statute, New York correction law, and New York civil practice law and rules. It says, Pamela Smart's case was subjected to a type of media scrutiny that the world had never seen. News stations sensationalized any purported detail of the case that they could get their hands on. And I have to interject here. This was 1990, 1991, and they talk about it being crazy now. So apparently it was the same back then. It says allegations ran wild. It was a trial by media in the purest form. We hear that all day, don't we? The snowballing thirst for scandal. These words, right? We talk about our semantics. The snowballing thirst for scandal. I have to write that down. Snowballing thirst for scandal led to the trial being the first in our country's history that was televised from gavel to gavel. That's interesting right there because we've been talking about, just making a note, we've been talking about in the Carmelo Anthony case, we've seen it a little in the Tyler Robinson case, media for and media against. This is groundbreaking, this case that was televised from gavel to gavel. Consequently, Pamela Smart became a caricature, a conceived identity. We've got the alliteration going on, don't we? No longer a person, but a story long departed from any possible reality. Such circumstances primed Miss Smart's trial to challenge the bounds of normal trial practice. So that means that should be interesting for us, right? In turn, Miss Smart's trial failed to retain critical constitutional rights, that's why we're talking about it, and safeguards required to ensure a fair adversarial testing process. In short, Miss Smart did not receive the fair trial that she was due. And this is why we talk about it. This is why I like going through these cases, because we want to make sure that everybody in the United States gets the same protection, equal protection under the law, and that God forbid if one of our family members were facing this, we all want to have our due process, right? It says here, a renewed examination of Miss Smart's trial has revealed meritorious and unreviewed issues that occurred and that warrant reversal of Miss Smart's convictions. Typically in these habeas petitions, we have to find new stuff. Specifically, Ms. Smart brings the following allegations of error in this petition. The state's case against Ms. Smart depended on heavily distorted audio tapes of surreptitiously recorded conversations of Ms. Smart. The state provided what the state purported to be transcripts of these conversations to the jury. I think I know where this is going. To read along when the jury first listened to the distorted audio tapes. These transcripts deceptively directed, there's a lot of alliteration here, isn't there? They deceptively directed the jury to hear Ms. Smart making inculpatory statements not actually present in the audio. A recent 191 participant study has affirmed that an average juror would hear something different than the confessions the state assigned to Ms. Smart if the juror did not have the state's transcripts or had a different transcript, but a juror will hear the state's assignments if provided the state's transcripts to read along the first time hearing the audio. Therein, the state's transcripts imposed an insurmountable cognitive bias on the jury against Ms. Smart. This prejudice was substantial, as the record expressly reflects that the jury's interpretation of these conversations was the final impetus to convict. Now, let me tell you guys know that I do some defense work, and I have had some cases where the court-appointed transcriptionist cannot seem to transcribe the audio properly. And I have had this happen to me where they just put unintelligible. I've done transcripts. I mentioned to you guys, maybe you know, maybe you don't know. I started out as a paralegal in the public defender's office, and one of my jobs was transcription. And there's certain terms that you put unintelligible when you can't understand what they're saying. But these transcripts, I had to report back to the court because I was hearing it plain as day. And it was wildly distorted in this particular case. Even the AI, now we have AI, did a better job. And I had to ask the court to fix it, fix all of them in the case. We had about 10 or 12. And the paralegal or the transcriptionist got a little teed off, okay? But it was required because it was not accurate. So this is very interesting to me. If you can't do your work properly, there's no excuses for shoddy work, whether it's police work, prosecutor work, defense attorney work, transcriptionist work, evidence work, forensic work. We don't like that, right? Okay, so this, I get it. I get it. They have AI now. You can very quickly put a body-worn camera through, an audio tape through, and let the AI make a first pass at it, okay? It should not be incorrect. So this would be interesting. It sounds like they let 191 people listen to it, and they all heard something different, or it did not agree with what the transcript said. And they said that a juror will hear the state's assignments, meaning the juror will interpret what the state said it said if they had the transcript when they first heard the audio. But if they didn't, they were hearing something different, okay? Which can be bias, right? If you go into something without a preconceived notion, it could be anything. But if you go in with a preconceived notion, as tunnel vision, bias, we can have problems. This is interesting. This is very interesting, right? In my case that I worked, how many cases has this same transcriptionist worked on other cases? They didn't get it. All right, number 2, trial counsel violated Ms. Smart's fundamental constitutional rights by declaring Ms. Smart's guilt to the jury. Is that her? I'm assuming that's her counsel. Trial counsel's concession of Ms. Smart's guilt without Ms. Smart's consent amounted to structural error and a presumption of prejudice. I'm assuming that's defense attorney. Now, we've heard before, I believe it was the Carmelo Anthony case, not sure, about structural error when they're talking about foundational structural error, constitutional, like structure of the house, bedrock, everything is based on that structural error, so it can't be wrong. Now, I don't know about this case. I don't know what the defense theory was or what they were going to say, but I will tell you that when you have an attorney that is leading the show, the attorney does make a lot of the decisions, and that is where we end up coming to, unfortunately or fortunately, ineffectiveness of counsel. They say trial counsel. It doesn't say defendant's trial counsel. So I'm assuming it's defense trial counsel. 3, Ms. Smart was convicted on an inflammatory news media story and not the judicially reviewed evidence produced during trial, as has been admitted by a juror. Holy goodness gracious. And this violation of Ms. Smart's constitutional rights denied Ms. Smart a fair trial. Now, remember, the jurors are not supposed to hear or read anything about the case. They're only supposed to see, good or bad, we talk about this too, what's presented at trial, what is allowed in. And it sounds like somebody heard a news media story or passed it around or something. That's interesting too. 4, trial counsel failed to correct and consented to erroneous jury instructions, so I'm assuming that's defense attorney, that alleviated the burden required for the state to convict Ms. Smart, and this constituted prejudicial error. Namely, jury instructions failed to instruct that Ms. Smart must be found beyond a reasonable doubt to have acted with deliberation and premeditation. That sounds like an element of one of the charges. Remember, you have to meet the burden. You have to connect the dots of all the elements of the crime. Further, the trial court did not instruct the jury to only consider evidence presented during trial. What were they asking them to consider? Lastly, the trial court improperly imposed the influence of the bench in supporting the facts submitted by the state. The bench is the judge. Ms. Smart was denied due process when the trial court imposed a mandatory sentence on a charge, on a charge that did not carry a mandatory sentence. The state chose to charge Ms. Smart with accomplice to first-degree murder and with the substantive crime of first-degree murder. These two counts are statutorily distinct, and only the latter carries a mandatory sentence. Elements of the crime and the penalty phase according to the elements of the crime. Okay, and we could look at that. That's very interesting. Ms. Smart petitions this court to reverse all findings of guilt and to grant a new trial on all the charges, or in the alternative, for a new sentencing hearing. Jurisdiction. New Hampshire's refined habeas corpus statutory scheme, in conjunction with the Interstate Corrections Compact as statutorily adopted by both New Hampshire and New York, restrict Ms. Smart's ability to file this petition for habeas corpus relief to the county of her detention in New York. Specifically, New Hampshire commands a petition be filed in the county of current imprisonment, and the Interstate Corrections Compact provides that New York may be assigned such jurisdiction. Inasmuch New Hampshire's self-exclusion renders New York the apt forum that can provide Ms. Smart her due relief. I don't know what they're doing between the two states. Though uncommon, here they're going to tell us, New Hampshire maintains the right to deputize New York, and New York has every right to assume agency. States are afforded immense freedom in where they place their prisoners and how they administer their correctional system. See Meacham v. Fano, Montagne v. Hames. Now, thinking about this, usually we think about transferring probation or parole, right? That I know is done through an interstate compact, but I didn't know that apparently you can house your prisoners in different states for you. I don't know. It says, nonetheless, this appears to be an issue of first impression. Therefore, Ms. Smart jointly files this petition in New Hampshire and in New York to involve all interested parties and relevant venues in determining jurisdiction and ultimately to abate delay in having this petition considered on its merits. It sounds like they were like, we're going to file it everywhere just to cover it. It says New Hampshire's revised statute 53 subsection 3 confers jurisdiction over a petition for habeas corpus strictly onto, quote, the superior court in the county in which the person is imprisoned, end quote. When they wrote it, they were probably thinking that only people imprisoned in New Hampshire would be filing these petitions, that they would only be housed in New Hampshire. It says New Hampshire enacted the common law remedy of habeas corpus into the statutory scheme currently found in Chapter 534 of the revised statutes of the state of New Hampshire. Therein, they're entitled to a writ of habeas corpus. It says the remainder of Chapter 534 commands how this right shall be procedurally afforded. This statute has been subjected to the microscope and amended into its current iteration. The statute faced scrutiny during New Hampshire's 1994 legislative session. The modifying bill was titled Criminal Procedure Habeas Corpus Filing Requirements and was self-described as, quote, an act requiring a writ of habeas corpus to be filed in the superior court of the county in which the person is incarcerated, end quote. They were doing something on that in New Hampshire, but what happens when the person is housed somewhere else? It says it was approved on May 6, 1994, became effective on January 1st, 1995. Henceforth, New Hampshire has inferred contentment with the statute for 30 years, leaving it to read as it currently does with no later alterations. New Hampshire, in turn, has restricted where a petition for habeas corpus relief can be filed with an unambiguous shall in the form or place of an affable may. Now, this is very important when we talk about semantics and legal documents. Shall means must. I know it says shall, and sometimes shall sounds like maybe, but it's not. Shall means must, and may means might, may. But shall is shall. That is a rule. You must. Every time shall, think must. Notably, New Hampshire had already adopted the Interstate Corrections Compact prior to amending the statute. New Hampshire had real-time prudence into the jurisdictional imposition it was creating. Ms. Smart had already been transferred by New Hampshire to New York under the compact's terms before New Hampshire amended New Hampshire Revised Statute 534, subsection 3. This was not some conceptual quagmire unforeseeable at the time. Instead, New Hampshire actively conferred jurisdiction over Ms. Smart. We got let's see. This is talking about the bill changes, and it looks like it went from may to shall. It looks like it went, but there's the shall change right there. All right. Certainly, New Hampshire would not or could not limit jurisdiction to deny transferred prisoners access to a habeas filing. Due process sirens would promptly subdue such an offense. What they're saying is, look, New Hampshire certainly wasn't trying to deny anybody due process rights under habeas. And they're talking about this here, okay? Therefore, New Hampshire had requisite notice, if not awareness, of the full impact of its statutory change. So if they come back and they try to say, you shouldn't be filing that garbage in New York, they're going to say, well, you have to, because that's the county where she's incarcerated. And there's your law that says shall. But they did. Remember, they did file it in both. Okay, so they're saying, look, New Hampshire knew what it was doing. It knew it had this interstate compact. So what were they thinking? It says, moreover, conferring jurisdiction is not an incomprehensible notion. New Hampshire has long rationalized the concept of conveyed sovereignty. That's interesting. The Supreme Court of New Hampshire has endorsed New Hampshire's ability to assign sovereignty to partner states through interstate compacts since at least 1964. See Dresden School District versus Hanover School District. That's interesting. Holding the New Hampshire Constitution allowed for control of some state operations to be conveyed onto a quorum that included out-of-state voters. Goodness, I don't know what is going on in New Hampshire, okay? I don't know. That sounds like a mess. To quell any uncertainty, the Supreme Court of New Hampshire has since held that held the filing constraint ascribed in the statute to be a strict jurisdictional bar. State v. Giskolka. He filed to vacate a conviction, obtain a new trial, which the court interpreted as a petition for habeas. Finally, he filed the request in the circuit court after the 1994 amendment. The court explained that prior to the amendment, the statute, quote, stated merely that a petition for writ of habeas corpus may be made to the Superior Court, end quote, but, quote, the legislature amended the statute to provide that such petitions, quote, shall be made to the Superior Court. That's where it has to go. Quote, the absence of any statutory authority to consider the extraordinary relief sought by the defendant here deprived the circuit court of jurisdiction to consider the merits of his motion. So typically it hops up a court, okay? And then it hops up and hops up ultimately to the U.S. Supreme Court. They're talking here again about this jurisdiction. I'm not going to go through, this is like crazy. So it says something here, the court took an opportunity sua sponte. Jeskolska's fight for relief was dismissed without regard to the issues raised. Other states with proximity-based jurisdiction statutes have set a similar standard in denying habeas relief due to improper jurisdiction. So we can kind of see where this is going. That's why they filed it in both places. They're quoting these state cases here. All right, they're citing all those case precedents. Now they're saying the Interstate Corrections Compact allows New Hampshire to confer jurisdiction and New York to accept jurisdiction. Now, I don't know, is New Hampshire better for a habeas evaluation or is New York better? New Hampshire has contracted Ms. Smart's sentence of life without the possibility of parole to be administered by New York. Ms. Smart was transferred to New York after the first 2.5 years of her incarceration. At this point, Ms. Smart has been incarcerated in New York for over 30 years. Ms. Smart was relocated to New York pursuant to the Interstate Corrections Compact, the ICC. The ICC establishes a framework for the reciprocal use of prison space by states to effect economies in capital expenditures and operational expenses. New York and New Hampshire have adopted the ICC. Who knew? The ICC establishes the rights and duties of the respective states sending and receiving prisoners. Generally, the receiving state acts as an agent for the sending state. The rights of transferred prisoners are also clearly established. Transferred prisoners must be given all legal rights they would have received if confined in the sending state. Okay, so New Hampshire law applies to her even though if she's in New York. It says, in the event of conflict of law, the sending state law governs. So that's New Hampshire. All right, and they're going more into that. And they're going to keep arguing this again. So we've got huge issues here over who has it, okay? So they're talking about who's going to administer this habeas. So it says, unambiguously, Ms. Smart is entitled to a hearing on this petition, and New Hampshire authorized the appropriate authorities in the county of her imprisonment in New York to provide it. Statutorily, nowhere other than New York can provide Ms. Smart relief. So hopefully they're liking New York better than New Hampshire. C. Federal habeas corpus filing requirements similarly restrict jurisdiction to the district of current custody. Ms. Smart faced a similar query when filing her federal petition for habeas corpus relief in 1997. So this is not her first go-round with this, apparently. Ms. Smart initially filed in the district court for the Southern District of New York due to being incarcerated in New York. A New York State correction official who was named as the respondent moved to dismiss the petition for improper venue or in the alternative to transfer the venue to New Hampshire. Unfortunately, the case lands little guidance as the filing was empowered and centered different laws. While the federal habeas and the state habeas both share a common law origin, they have been statutorily curated by the independent sovereigns. The jurisdictional language empowering the federal habeas is far more flexible. Prior to Ms. Smart's 1997 filing, the Supreme Court of the United States interpreted the phrase, quote, within their respective jurisdictions, end quote, as requiring, quote, nothing more than the court issuing the writ have jurisdiction over the custodian, end quote. Therefore, a federal habeas corpus petition could be brought in any court with jurisdiction over the prisoner or their custodian. So I'm not sure if this is a federal or state habeas. Ultimately, the court held that, quote, either the appropriate New Hampshire official or the agent custodian in New York would be a proper respondent. The court concurrently recognized that in federal civil cases, venue may be changed pursuant to 28 U.S.C. 1404A, which provides, quote, for the convenience of parties and witnesses, in the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought, end quote. Habeas corpus cases are civil in nature and are embraced by the term, quote, any civil action, end quote. Thus, 1404A was applicable to Ms. Smart's habeas corpus proceedings, and the court conducted an analysis of whether, quote, a change of venue would serve the interests of convenience and justice, end quote. Okay. The court held that a transfer of venues would be in the interest of justice, so the court granted respondent's motion requesting as much. If Ms. Smart's federal habeas case had any influence on the present matter, arguendo, the holding on jurisdiction has since been abrogated by the seminal Supreme Court case of Rumsfeld versus Padilla, Trump versus JGG. In that case, Jose Padilla filed a petition for writ of habeas corpus challenging his detention as an enemy combatant pursuant to an order from the president. Padilla was apprehended in Chicago, taken to New York, and then was moved to a Navy brig in Charleston, South Carolina. Padilla filed a federal habeas petition in the district court for the Southern District of New York and named the president, secretary of defense, and the commander of the naval brig as respondents. The Supreme Court was asked to confront jurisdiction. The court held that the commander of the naval brig where Padilla was detained was the only proper respondent, and that the district court for the Southern District of New York did not have jurisdiction over the commander. Padilla could not, quote, name someone else just because Padilla's physical confinement stems from a military order by the president. Identification of the party exercising legal control over the detainee only comes into play when there is no immediate physical custodian, end quote. So it says the immediate custodian rule as imposed by Padilla has repeatedly been recognized in the First and Second Circuits. Furthermore, jurisdiction has been held to be bound to the date of the filing. Subsequent move of a prisoner will not displace the jurisdiction. In other words, if a court had proper jurisdiction at the time of filing under Padilla and under the immediate custodian rule, that court retains jurisdiction even upon a transfer of the petitioner back to the sending state or to another district. So it says, okay. Relevant law thus dictates that Ms. Smart's habeas petition be heard in New York, applying the laws of New Hampshire. That's going to have to be crazy for the court. The rules and all that. This is going to be crazy confusing. Okay. In summary, the plain language of New Hampshire's revised statute 534 subsection 3 unambiguously confers jurisdiction over a petition for habeas corpus strictly onto, quote, the superior court in the county in which the person is imprisoned, end quote, which in this instant case is the Supreme Court of Westchester County. This interpretation of New Hampshire's statute is supported by the terms of the Interstate Corrections Compact, of which both New Hampshire and New York are signatories, by which, quote, the receiving state, end quote, New York, quote, has been authorized by the sending state, end quote, New Hampshire, to administer a hearing, quote, to which an incarcerated individual confined pursuant to this compact may be entitled by the laws of the sending state, end quote, namely a hearing on Ms. Smart's habeas petition. Oh, goodness. Furthermore, this understanding aligns with the, quote, immediate custodian rule, end quote, applied in federal courts, wherein the proper respondent is, quote, the warden of the facility where the prisoner is, being held, end quote, Padilla. Therefore, Ms. Smart asserts that her habeas petition is properly before the Supreme Court of Westchester County, New York. In the alternative, should this court find such jurisdiction improper, Ms. Smart maintains and exerts her right to seek relief in the Superior Court for Merrimack County, New Hampshire. Holy cow. Holy cow. Ms. Smart, okay, now we're going to talk about the procedural history. Ms. Smart was indicted by a Rockingham County grand jury on August 4th, 1990 on the charges of witness tampering, conspiracy to commit murder, and accomplice to first-degree murder. So she was indicted, okay? Ms. Smart was not charged with first-degree murder. 3 motions to change venue and a motion to suppress his statement were made prior to trial, all of which were denied. A subsequent motion to reconsider venue and a motion to sequester the jury were likewise denied. Now remember, they talked about somebody seeing some news and stuff. Okay, so it sounds like they were not sequestered. They also wanted to move the trial because probably, I'm assuming, the media coverage. And now what are they alleging? Media issues. Voir dire, that's the jury questioning, began on February 19th, 1991, and a 14-day trial began on March 4th, 1991. Ms. Smart renewed her motion to sequester, that's where they all get locked up, not locked up in prison, but sequestered, on the first day of jury deliberation, but was again denied. The trial court, however, belatedly sequestered the jury on the second day of jury deliberation. On March 22nd, 1991, the jury returned guilty verdicts on all 3 counts. So 14-day trial began March 4th. So that would have been the 18th of March, and they returned the verdict on March 21st. So they deliberated maybe 2 days. The trial court imposed a 3.5 to 7-year sentence on the witness tampering count, a 7.5 to 15-year sentence on the conspiracy to commit murder count, and declared that the court was mandated, remember they talked about that, to impose a life without the possibility of parole sentence on the accomplice to first-degree murder count. Now remember, the defense is saying that is not a mandatory. That's not a mandatory charge. Ms. Smart filed 4 post-trial motions for relief in the New Hampshire Superior Court, which were heard on August 19th, 1991 and August 26th, 1991. These 4 motions were a motion for a new trial based on juror misconduct, a motion for a new trial based on failure of due process, a motion for individual voir dire of the jurors, and a motion for new trial based on exculpatory evidence. The Superior Court denied all post-trial motions. Ms. Smart timely pursued a direct appeal of her convictions to the New Hampshire Supreme Court. The New Hampshire Supreme Court affirmed the convictions on February 26, 1993. A motion for reconsideration was denied on April 29, 1993. A petition for certiorari to the Supreme Court of the United States was similarly denied. They wanted the Supreme Court to hear it, and they said no. The Supreme Court doesn't hear everything. 4 years later, Ms. Smart filed a petition for habeas corpus before the New Hampshire Superior Court. The filing went before the same judge that oversaw the trial. Yeah, see, I think it was Carmelo Anthony, they're asking for a different judge, right? This is why. The court found no error in its own actions and denied all claims made on June 13th, 1997. So what do you think? Do you think the same judge should hear it? The New Hampshire Supreme Court summarily affirmed. Ms. Smart then filed a timely petition for federal habeas relief. The petition was initially filed in the United States District Court for the Southern District of New York, where Ms. Smart was and is currently incarcerated pursuant to an agreement between New Hampshire and New York. The case was transferred to the United States District Court for the District of New Hampshire, and it was held that while Ms. Smart was incarcerated in New York, Ms. Smart was still in the custody of New Hampshire. The petition for federal habeas relief was denied on September 20th, 2002. A petition for certiorari to the Supreme Court of the United States was denied. Consequently, Ms. Smart is currently incarcerated at Bedford Hills Correctional Facility as inmate number 93G0356, serving life without the possibility of parole. So I'm not sure what just happened in the federal. It sounds like a jurisdictional challenge. I'm not sure. So I think this is going to be very interesting from the procedural standpoint, especially with this interstate compact and the filing charges, the jury instructions, and the jury misconduct. I'm going to end here, and I'm going to continue on with these so that we can learn what happened in this case, right? So they're saying that the media influenced it. They say that the jury, there was some news information that apparently got to the jury. The past case, the habeas, was seen by the same judge that heard the trial. And one of the counts was, I believe, Potentially, I'm not sure because they haven't elaborated that yet. Now they're arguing that the charging of the jury or whatever, or the sentencing position was wrong, and it was heard by the same judge that did the thing. And that's why we're probably seeing it in the other cases that they're asking for a different judge. Do you believe that the same judge should hear the case? So you want the same judge that heard the case to decide if that judge erred, if they themselves erred, right? Makes sense. And then all this New Hampshire, New York thing, that will be very interesting. And so they did apparently hear the oral argument yesterday, and I will try to see what state they had that in, because I think that will be interesting. It's pending, and we need an answer on that. So lots more to come. Thanks for being here. I appreciate your following, liking, and subscribing, and helping continue the mission. Thank you for helping us help solve the cases, and I would love to hear your comments and what you think. I will see you on the next one.